Good morning. My name is Tracy Lee. I am the Family Engagement Specialist and Special Projects Coordinator at the Virginia Department of Education. I am coming to you this morning from my house, which I'm sure isn't surprising to any of you because most of you are probably in your houses right now too. Today we're going to be talking about critical decision points for families of children with disabilities. This is the first of 5 sessions that we are going to be doing. We had to cancel because of COVID-19. We had 5 or 6 critical decision points trainings scheduled throughout the Commonwealth in March, April, and May. And we obviously had to cancel all of those. It is our intention to reschedule all of those trainings, but we just don't know right now when that's going to be. So what we decided to do was take the training and we have condensed it into 5 short sessions. I think the longest will probably be 30 to 45 minutes, and then some might be more like 15 minutes. We're going to take these 5 trainings and we're going to post them, and then you can take a look at them whenever it works out for you. If that's in the morning, if that's late at night, if that's on the weekend, whenever you as a parent have some time to look at these trainings, you are welcome to do that. My contact information, we will talk about it, is going to be at the end of this PowerPoint. So if you have questions about anything you see here, you can give my office a call. I check my messages several times a day, and you can also send me an email and we can schedule a time to talk about your specific questions. This is the Critical Decision Points for Families of Children with Disabilities guides. Hopefully many of you have seen that. Once we are able to get back into our offices at the VDOE, if you would like, we can actually mail you one of these. But in the meantime, at the end of this PowerPoint, you'll see this as well. There's a link to our website to an accessible version that you can view online or that you can download and print yourself if you'd like, until we can get these to you again. There's also going to be a link to some virtual web-based training modules. They're animated. They're very short. They're about 3 minutes in length, 2.5 to 3.5 minutes, and they give you an overview of this information and guide you back to this document if you need further information. The first session today, we are going to talk about 3 things. We're going to talk about being engaged in your child's education. We're going to talk about understanding your rights as a family member of a child with disabilities. And we're going to talk about what to do if you disagree with an eligibility or IEP team decision. How can you proceed, and what are your options at the state level? The first thing we're going to talk about is why this training was created. The VDOE was approached by the Virginia Board for People with Disabilities because they were hearing from a lot of people with disabilities and parents of people with disabilities that there was information that they needed in order to make decisions about their kids' special education. But they also needed to know when they needed to know that information. So sometimes they got the information that they needed, but they got it too late in order for it to really positively affect decision making. And so the Virginia board approached the VDOE, and they talked to us about offering us a grant, and then we would create this curriculum, which we did, Critical Decision Points for Families of Children with Disabilities. So that's how all of this got started. Before we get started, there are some things to note. Number 1, in the world of special education, information changes rapidly, especially right now. There's a COVID-19 section on our website that's being updated constantly, so you might want to check that out. Your best source for the most accurate and up-to-date information is the Virginia Department of Education website. Everything that we're going to be talking about today is current and up-to-date information, but as we move forward, if you stumble across this recording a year from now, there's a possibility that things have changed. So that at the bottom there, doe.virginia.gov, that's the place to go for the most up-to-date information. One more thing before we get started. I mentioned that I'm at home. I'm at home with my husband and with 2 of my 3 kids, and I think everybody is going to be quiet and cooperative, but I cannot guarantee that. So I'm going to go ahead and apologize in advance for anything you see or hear that maybe you wouldn't see or hear if I was in my office at the VDOE. Okay, first thing we're going to talk about, key number 3, being engaged in my child's education. If you look in this guide, you will see that it is divided up into keys to academic success and critical decision points. So key number 3, being engaged in my child's education, is where we are if you're following along in your guide. If you have a child who receives special education services, you have two very important roles. Your first is to build and maintain a solid working relationship with all school personnel involved with your child so that the IEP team can function at its most effective level. That leads you to your second most important goal, which is to ensure that your child receives FAPE, which is a free and appropriate public education. We at the VDOE believe that the best way to attain these goals for your child is to remain engaged in your child's education through collaboration with your school division. So what does that look like? What is family engagement? Here's what family engagement means. Ideally, parents who are engaged may do any of the following: encourage communication with your child, talking to your child, communicating back and forth with them, listening to what they say that they need as a result of their education. You want to support and model an enthusiasm for learning. This is letting your child see that you believe that learning is not something that happens just between 8 and 3 in a building down the street. Learning is lifelong, learning is all day long, and they need to see that you believe that in your own life. So if, for example, they ask you, why is the sky blue? And you might say, I don't know, let's go find out. And they can see that you are learning, you are reading, you are trying to gain information for yourself because you find value in education. Assisting with study habits. And this is more than just checking off to see if they've done their work. This is actually assisting the child with things that they might be struggling with. For example, if your child has something that they have to memorize and that's difficult for them, maybe sitting down with them and saying, let me show you some tools that worked for me when I was younger. Actively participating in meetings. For our purposes as families of children with disabilities, we're talking about meetings such as parent-teacher conferences, but we're also talking about the big named meetings like IEP meetings, manifestation determination meetings, and eligibility meetings. You want to understand your child's needs, and we also want to understand that if we have more than one child, they have different needs. Not all kids have the same needs, and we want to try to meet the needs of all of our children. Understand the special education process and parent-child rights. We're going to talk more about that in a little bit. And then advocating for your child's educational needs. So the fact that you're sitting here watching this recording tells me everything I need to know about whether or not you're an engaged parent. You obviously are, because you're here trying to learn more about how you can most effectively impact and positively impact your child's education. So that's a great thing. So we talked a little bit about what family engagement is. Let's talk about what it's not for just a minute. Sometimes we are asked by our schools to do things like sell wrapping paper or attend a literacy night. And these things are part of being engaged, but it's not the whole thing. I know that there are many families out there who sometimes feel like they are not able to be engaged in their child's education because they're not able to show up at the stuff, because maybe they're working 2 jobs or they have all of these other responsibilities and they're not maybe able to come to something on a Tuesday evening, but they sit at the kitchen table with their child every night and help them to do the work that they need to do and learn what they need to learn. That parent is engaged, okay? That's showing up in the building does not always equate with engagement. It can be part of it, but it's not the whole thing. So if you are one of those parents who has a whole lot going on, and we all have a whole lot going on, and you can't always show up at the Tuesday evening 7 p.m. meeting, that does not mean that you're not engaged. Okay, you are very possibly very effectively engaged in your child's education. Your engagement just looks a little different from someone else's. So just remember that and keep that in mind. What does collaboration mean? Collaboration is when 2 or more parties are involved in a partnership with the purpose of working together toward a common goal. It's a process, it's not an activity, and it's fostered through all parties learning how to communicate effectively with one another as a means of building trust. Family engagement, which is what we just talked about, leads to better collaboration with our school divisions, and collaboration between families and schools leads to better outcomes for our kids. That's why family engagement is important. Okay, the next thing we're going to talk about today is key number 4, understanding your rights as a family member of a child with disabilities. This is not a complete list of your rights as a family member of a child with disabilities. That would be the procedural safeguards document that you receive at every IEP meeting, every eligibility meeting, every manifestation determination meeting, and every time you request it. That document is a full and comprehensive listing of your rights. We're just going to hit some of the high points today. You have the right to advocate for your child without fear of retaliation. That is retaliation against your child, but it's also retaliation against you. So let's talk about for a moment when we might have a situation where a parent is retaliated against. Let's imagine for a moment that you are a parent who also happens to be a teacher in a school division where your child goes to school. And you're having a disagreement with your IEP team. And so you and your IEP meeting are having to very strongly advocate for your child with people who sign your paycheck. That might be a little bit uncomfortable and a little unnerving for some parents. So that's why it's important for you to understand you cannot be retaliated against because of your advocacy for your child with disability. It's very important for you to understand that and to know that. You have the right to receive advance notice and invitation of all meetings. When we say all meetings, we mean the named meetings in IDEA, manifestation determination meetings, eligibility meetings, and IEP meetings. In Virginia, more than 2 people are considered a meeting. So here's an example of a meeting that you would not have the right to advance notice or invitation to. Let's say that there's a reading goal in your child's IEP. And so your child's reading teacher is going to meet with 2 other reading teachers after school to discuss some instructional strategies to help your child to meet that goal. Under the Code of Virginia, that is considered a meeting, but it's not one of the big 3 named meetings that you would have the right to advance notice or invitation to, okay? You have the right to have meetings at a mutually agreed upon date, time, and location. Mutually agreed upon date, time, and location is not a parent saying, I can only meet on Saturdays at 2. It's also not a school division saying, we only have IEP meetings on Tuesdays, okay? There has to be a good faith effort by both parties to have the meeting at a mutually agreed upon date, time, and location. So when might location come into play? Location might come into play when you have a situation where maybe a parent has been convicted of a specific kind of a felony where they can't be around other children, okay? That parent still has the right to participate in their child's IEP meetings, eligibility meetings, all of those meetings. So you might look at a location like a courthouse or somewhere where there aren't other children present, where you can have that meeting. You can also play with location a little bit. You can use Zoom, you can use FaceTime, you can use like a conference call. There are all sorts of ways that you can play with that, but just understand you have the right to have a meeting at a mutually agreed upon date, time, and location. You have the right to audio record eligibility, IEP, and manifestation determination meetings across the board. You always have the right to record those meetings. You have the right to request to video record. This one's a little more confusing. So what does that mean? Every school division in Virginia has the right to create their own policy on video recording, their own written policy. That written policy might be, we never ever allow video recording. That written policy might be, we allow video recording only under these certain circumstances. Whatever that written policy is what you have to follow. So if you request a video record and they say, here's our written policy, whatever that written policy says, that's the rule. That's what you have to do. But if you request a video record and you're told no, that you cannot video record, and you request to see the written policy, if there is not a written policy, if they have no written policy on video recording meetings, then you can video record, okay? So if there's a written policy, you have to follow it. If there's not a written policy, you can video record. That's how that works. You have the right to discuss your concerns and input in the IEP meeting and meaningfully discuss your concerns and input. This does not mean in the last 60 seconds of the meeting, okay, when everybody's trying to rush to get back to class because they have substitutes and things like that. As a parent of a child with a disability, I've had 1 or more children either currently have or have had IEPs. The way I would approach that is this way. At the beginning of the meeting, I would say, I have about 10 or 15 minutes worth of stuff I need to talk about, worth of concerns and input. We can talk about it now, we can talk about it in the middle, or we can talk about it at the end. But I just want to be certain that we as an IEP team carve out that 10 or 15 minutes or however much time I think I need in order to discuss my concerns and input so that they don't get pushed to the end in the last few seconds of the meeting. Just put that out there at the beginning of the meeting so you can ensure that you get that time. You have the right to bring in, have reviewed any type of documentation to the IEP meeting. You can bring doctor's reports, you can bring outside testing evaluations, you can bring any kind of a log that you've kept for your kids. You can, I hear a lawnmower outside my house, by the way, so sorry about that. That's one of those things that I can't control when I'm working from home. So if you're hearing that, I apologize. Okay, so any type of documentation, I don't care what it is. You can bring anything. You can bring in a report from your astrologer if you want to. You can bring and have reviewed by the IEP team any type of documentation that you want to bring and have reviewed. That is your right. You have the right to bring other individuals and have them assist you during meetings. You can bring anybody you want to bring. You can bring your Aunt Sally. You can bring your next door neighbor. You can bring an advocate. You can bring an attorney. You can bring anybody that you want to bring. Couple things to think about here. Number one, very often space is at a premium in school buildings. And so unless they hear otherwise from you, the IEP team is going to probably assume that it's going to be you and maybe one or two other people. So they might have a space set aside that can accommodate maybe 7 or 8 individuals. Well, if you show up with 5 or 6 people and they only have space for 7 or 8 people, and they've got 5 or 6 people of their own, the first 15 or 20 minutes of your child's IEP meeting might be spent trying to find space that can accommodate all of you. I don't know about you all, but as a parent, I want every minute of my child's IEP meeting to be spent talking about my child and not to be spent looking for space to accommodate us. So if you're going to bring a bunch of people, I would definitely let them know that ahead of time, just so that you can make sure that, you know, a big chunk of your IEP meeting isn't going to be spent looking for time. Another thing to consider. In the last section, we talked about how you have 2 goals as a parent. One is to, or a parent of a child with a disability. One is to create a collaborative relationship, strong collaborative relationship with your school division, so that the second one, we can reach the second one, which is assuring that our child receives FAPE. If you show up to a meeting with an attorney and you have not let the school division know that you're going to do that, I'm just going to go out on a limb here and say, anytime you show up to any conversation and bring your attorney and didn't let people know ahead of time that you were going to do that, that probably doesn't go a long way toward establishing a strong collaborative partnership with someone. Having said that, you are absolutely within your rights to bring an attorney to a meeting without letting anybody know ahead of time that you're doing that. You have the right to do that. But if you want to think about this from a realistic perspective and you want to think about that strong collaborative partnership, it might be better if you're going to bring an attorney to let the school division know ahead of time that that's going to happen so that they can be prepared for that. Again, though, that's just, sometimes there are unintended consequences to our actions, and I just want you to understand that there can be unintended consequences, but you 100% have the right to show up with an attorney without letting them know ahead of time if you would like to do that. You can do that. You have the right to receive a copy of the procedural safeguards document once per year and at any time upon request. And if you request a hard copy, you call the school and you say, I would like a hard copy of my procedural safeguards document. An acceptable response to that by the school division is not, it's on our website, you can go download it and print it yourself. If you request a hard copy, you should receive a hard copy anytime you want one. That's your right. You have the right to receive an independent educational evaluation when you disagree with the results of a school-based evaluation at no cost to you. There are some caveats to this one, one of which is that if your child has an evaluation and you disagree with the results, you can request the same evaluation to be done by an outside source at no cost to you. What you can't necessarily receive is a different evaluation. So you can't say, I don't like this testing instrument, I want another testing instrument used at no cost to me. Now you can certainly go out and have your child tested with a different testing instrument, but the school division would not be required to pay for that for you. Okay. And there are some other caveats on that. So if you have questions about this one in particular, you can feel free to email me or call me. And at the end of this presentation, I'll make sure that you have that information. You have the right to receive prior written notice Prior written notice is provided to you whenever the school division proposes or refuses any action related to these following items: the identification of your child with a disability, the evaluation of your child with a disability, educational placement, or the provision of FAPE. The term prior written notice can be confusing sometimes because prior leads us to believe it's something that happens before something happens, but we usually get prior written notice after meetings have happened. But it's prior to the implementation of any of these items: identification, evaluation, placement, or provision of FAPE. So whenever the school division is saying no to something you've requested, so they're refusing something, or they're proposing something new to you as a parent related to any of these things, you should receive prior written notice. Prior written notice must contain these 7 elements: the description of the action proposed or refused. So let's say you as a parent have requested a specific evaluation for your child, and let's say that the school division is refusing it. So they have to describe what it is they're refusing, the explanation of their proposal or refusal to take action. So why are we refusing this? They can't just say, nope, we're not going to do it. It's going to be, nope, we're not going to do it, and this is why we're not going to do it. The description of any other options considered and the reasons for their rejection. So we looked at this evaluation, but we also looked at these evaluations, and this is why we are going to reject these as well. The description of the evaluation, assessment, record, or report used as a basis for this action. So we're not going to do this, and this is the evaluation, assessment, record, or report we used in order to make that decision, in order to make this refusal. The description of any other relevant factors, a statement regarding your procedural safeguards protections, basically that you have those, and here is where you can find them. And then any sources for assistance. Sources for assistance can be all kinds of different things. They can provide you with contact information for our state's PTI, which is PTSI, our Parent Training and Information Center. Center for Family Involvement at VCU, the Special Education Director, the Parent Ombudsman at the VDOE, your Parent Resource Center, if your school division has one. There are many different things that can be listed here, but something has to be listed as a source where you can go to for assistance should you require it. So proper prior written notice has to have all 7 of these items in order for it to be prior written notice. Okay, so the last thing we're going to talk about today is critical point number 5. I disagree with an eligibility team or an IEP team decision. How should I proceed? And before we talk about this, I just want to show you how critical decision points. This is the first critical point we're going to talk about. In this booklet, they have a few different components, and I want to show you what they are. So we are looking at page 20 here right now. Do it really quickly. Okay, each of the critical decision points has information on the actual critical decision point. So what information do you need in order to make these decisions? It also has when to consider. So when is it that you need to begin thinking about this critical decision point? That's the second component it has. And then it has questions to ask the school. Sometimes parents will tell us, you know, I would love to be able to talk about this with my school or to ask questions to my school, but I don't even understand enough about this to even know what to ask. And so we've provided some questions for you so that you can use those to guide conversation. Okay, so those are the 3 components of the critical decision points in this curriculum. So dispute resolution options available to you through the Virginia Department of Education. First, let me say that the VDOE believes that it is best and fastest for any disagreement to be dealt with at the local level if possible. So you really do want to try to resolve your issues locally if you possibly can. If you can't, however, if you and the school division, you've gone round and round and round, you've communicated, you've collaborated, you've tried everything you can, and you still are not able to resolve your disagreement, you have these 3 dispute resolution options available to you through the Virginia Department of Education. We're going to skip down to the bottom first, and we're going to talk about complaints. Complaints are something that parents generally file when they feel like a school is not in compliance with the state regulations or with the federal law. So for example, let's say that your child's IEP says that they should be receiving speech services 3 times a week, 30 minutes at a time. But for whatever reason, maybe your child has only been getting speech once a week for 15 minutes at a time. You at that point would feel possibly that your school division was not in compliance with your child's IEP. And that's a situation where you might want to file a state complaint. They're generally expressions of some disagreement with a procedure or a process regarding special education programs, procedures, or services. There's information on our website about how to file a state complaint, and people at VDOE can help you through that process if you need it. If you file a state complaint, a complaint specialist at the Virginia Department of Education has 60 days to investigate the complaint, and they will determine, yes, the school division was in compliance, or no, the school division was not in compliance. If the school division is not in compliance, they might require that the school division provide compensatory services to the child. So for example, in the situation I just described to you about speech, the compensatory service might be something like you have to make up all of the time that the child has missed. And then you might even have to add some more to that for any maybe backsliding that the child has done as a result of not having received what the child should have received according to their IEP. Sometimes compensatory services won't directly impact your child. So what does that look like? Let's say, for example, there was a teacher who did something and it was determined that the school division was not in compliance because of the actions of this specific teacher. It might be determined that if this teacher didn't know that what they were doing was incorrect, it's possible that none of the teachers in that building know that that action is incorrect. And so the compensatory service might be that all general education teachers in this specific school building, in this specific school division, have to receive training on X. Okay, so that's a compensatory service, but it's not necessarily a compensatory service that's going to directly impact your child. Okay, it might be something that we're trying to keep this from happening to another child. So even though it's a compensatory service, it's not going to directly impact your specific student. Okay, that's what that might look like. Compensatory services are not going to be cash. It's not going to be, we would like a cash settlement because of what we have had to deal with as a result of this. That's not what compensatory services are. They are just that, they are services. Okay. The other two that we want to talk about are mediation and due process. These tend to happen when families and school divisions disagree on what is proper and what a child requires in order to receive FAPE. So let's say we have a situation where a parent believes that a child needs to be placed in the general education classroom with a full-time aide, but the school division thinks that the child needs to be in a general education classroom part of the time, maybe with an aide, and then in a self-contained classroom for part of the day as well. So the parent and the school cannot come to an agreement on what that placement should look like. You have mediation and you have due process. Mediation, it can assist parents and school staff when they are in negotiations. The Virginia Department of Education, if you request a mediation, will contact the school division and say, this parent has requested a mediation. Mediation is voluntary on both sides. So if one or either side does not want to come to mediation, mediation does not happen. But if both sides agree to come to mediation, the Virginia Department of Education will assign a mediator. They are contractors. They are not our employees, but we pay them for you. We'll set up a mediation. The mediator will try to help you work through your issues and see if you can come to a mediated agreement. If you can, that is enforceable in court. It's just, it has the same teeth as an IEP, okay? There's no cost to you. It can generally be set up pretty quickly. And I don't know what the exact number is, but it's somewhere around 80 to 85% of the time in Virginia, when parents and school divisions go to mediation together, they come out with a mediated agreement. So there's a pretty good chance that you might be able to work through your issues through mediation. If you don't want to do mediation, or the school division doesn't want to do mediation, or maybe you've tried mediation and it was not successful, you still could file a due process. Due process is an administrative hearing process before a hearing officer to resolve disagreements over any matter under FAPE, including disciplinary matters. So basically, you can think of this as sort of like taking them to court. Okay, you could file due process against the school division. Due process does not it doesn't cost anything. It's just like mediation, and there's no cost for the process. Where you might incur cost would be through attorney fees. The school division will just about, I don't think I've ever heard of a situation where a school division went to a due process hearing without having an attorney present. So you might be well served to have an attorney as well. And if you do that, you would be responsible for your attorney fees unless you prevail. In some cases, the school division would have to pay for your attorney fees, but that's sort of a gamble to take because you just don't know what's going to happen. So that's where cost comes into play with due process. So you would file due process, you go to this hearing. A hearing officer is going to be assigned by the Virginia Supreme Court. Hearing officers, again, they are paid by the VDOE, but they are not our employees. They are licensed members of the bar. You'll put on your case, the school division will put on their case, and the hearing officer will make a decision, and that decision will stand unless one party decides to appeal that in court. Okay, so that's how due process works. So those are the three options you have. If you have a disagreement, if you cannot come to an agreement locally, you could file a state complaint, you could go to mediation, or you could file due process against the school division. One more thing about due process before we close this section out. I just want to mention that parents typically are who file due process against school divisions, but it's not outside the realm of possibility for a school division to file due process against a parent. It doesn't happen very often, but it does happen. So just be aware that this is a two-way street. So if you cannot come to an agreement, you've tried to come to an agreement, lots of time has passed, and the school division feels like it will be in the best interest of the child to have somebody else decide this, they can possibly file for due process against the parent. So it's not one way. So it's important to understand. Okay, when do you want to consider this? Immediately once the disagreement occurs and cannot be resolved at the local level. And then questions to ask the school. What are my rights regarding dispute resolution? You can talk to the school about this, or you can talk to us at VDOE. How can we settle this disagreement so that my child's needs and best interest are being met? If the IEP team cannot resolve this disagreement, what is my next course of action? Is what we just talked about. Okay. So that's all we're going to talk about today. That wraps up section 1 of this training. If you look at this slide right here, and I'm going to leave it up for a minute to give you some time to write this down. You can also email me, and I will send you this link. This is more information. If you click on this link, it will take you to the information for parents page on our website, and you will find this in an accessible, downloadable format for you to see. And you will also find the web-based training modules that I talked about before. So that is where you go to find those. And if you have questions, this is me and my contact information. You can email me, or you can call, like I said, you can call my office. I check my messages probably 3 or 4 times every day. So if you give me a call, I will definitely give you a call back. Because of the fact that we're all working from home right now, sometimes it's easier to email me and we can set up an actual time to talk so that we can make sure that we're both available at the same time. You can take a screenshot of that and write it down, whatever you want. And I'm more than happy to talk to you about your questions. We have 4 more of these recordings coming up that we'll be doing within the next couple of weeks. And I really appreciate you tuning in today. And I thank you very much for your time. Have a great day.